年仲裁修訂條例草案委員會而家開會，咁啊，我哋首先呢就係要選主席，有邊位嘅提名？係郭榮鏗議員。
Any nomination, please, Mr. Dennis Kwok. I nominate Dr. Priscilla Leung. Any seconder? Mr. Abraham Sheikh seconds. Miss Dr. Priscilla Leung, do you accept? Yes. Any other nomination? I don't think so. Okay. Dr. Leung, please come to take the chair. Please invite the administration to join us now.
Okay, 先喺呢度一路學嘅咯喎，一傾呢度嘅咯喎，一落呢度嘅咯喎，係啊，落嘅咯喎。首先歡迎政府嘅。
Let us welcome Mr. Peter Wong, Deputy Solicitor General from the Department of Justice, as well as Ms. Alice Choi, Senior Government Counsel from the same department. Can I give the floor to the administration to brief us on the important areas of the Arbitration Amendment Bill 2013 before we start our discussion? Thank you. Madam Chair. Regarding the Arbitration Amendment Bill 2013, there are two main objectives. First, through legislation, we would like to give effect to an agreement signed with Macau earlier in the year, and that is reciprocal recognition and enforcement of arbitral awards. And in light of development of the local and international arbitration industry, we would like to also make some appointments, and that is the enforcement arrangement for emergency relief arbitration. The court will be empowered to enforce the arbitral awards of an emergency arbitrator. And then there will be clear arrangements for the cost of arbitral procedures, and the costs are to be taxed on a party and party basis, and that's the usual criterion adopted in litigations. We also take this opportunity to update the New York Convention order, so that two new state parties to the convention can be added to the schedule. So these are the main areas of our amendments.
The policy direction of the DOJ and the government as a whole is to promote Hong Kong as a hub of arbitration in Asia-Pacific region. Thank you, Mr. Wong. I believe we have had quite a lot of discussion, especially in the last term. So, members, any questions? Mr. Tam Yu Chung? Yes, I want to know more. In 1999, we signed an agreement with the mainland on this subject, on this arrangement. Why did we have to wait so long? And before we had one with Macau, have we got a similar arrangement with Taiwan? Mr. Dennis Kwok? Well, apart from the bill, I want to know what the administration will do or plan to do to promote Hong Kong as an arbitration center. Mr. Peter Wong, concerning the two questions raised by Mr. Tam, let me give a response. Well, we will need to enter such an agreement with Macau in January 2013, because all along we have been focusing on the mainland. Because in terms of economic ties and trade, our relationship with the mainland has always been very close. So we can enter into an agreement with the mainland in 1999. And also after the reunification, we are within the same country, so we cannot do anything under the reciprocal enforcement arrangement. And over the years, we have also been trying to expand arbitration arrangements in the Greater China region. And with the reunification of Macau in 1999, basically, we can enforce Macau judgments or awards. But with an agreement, we can have a dedicated enforcement tool, which we believe is desirable. So in the past 2 years, we explored very actively with the mainland, with the Macau authorities. We are happy that in January 2013, we entered into this agreement, and the SPJ led a team from Hong Kong to Macau for the purpose of signing the agreement. We hope this bill can be enacted, and then we inform the Macau and implement the relevant provisions. The second question is about about Taiwan. As I've said, we have been trying to strengthen arbitration in the Greater China region. So apart from Macau, we also want to work on Taiwan. In previous AJLS panel meetings, we already said that we would be actively exploring possibilities. We have this work objective of reaching a similar agreement with Taiwan as soon as we can, so that we can have a dedicated instrument for the enforcement of arbitral awards. So simply put, this is also our work objective. Mr. Dennis Kwok asked whether, apart from the bill, what we'll be doing or what we have done to promote arbitration. On the 23rd of April, there was an AJLS panel meeting. We gave a briefing in that meeting, but I can briefly summarize what we'll be doing. Of course, a legal framework is one of the means, so the suitable amendments to the arbitration ordinance will be necessary, and that is the objective of the current exercise. Apart from the legal framework, we also promote overseas arbitration centers to have a presence in Hong Kong, for example, to have an office. Apart from Hong Kong ICB, we have Hong Kong ICC, Asian office, and CITIC, the Chinese International Economic and Trade Arbitration Commission, Hong Kong Arbitration Center. So on top of these, we'll continue to attract overseas arbitration centers to set up offices in Hong Kong. Apart from welcoming these world-class arbitration organizations to be represented here, we also promote our legal services and arbitration service in overseas countries. On the 27th of April, and that is after the last panel meeting, we organized a medium size in Xiamen with 300 odd practitioners and representatives from the business sector participating. We introduced to the participants our arbitration services in Hong Kong. So these are some examples of our efforts. On the 23rd of April, we submitted a paper in which there are other details and efforts through which we promote our status as an arbitration center. I know in 1992, Taiwan agreed to recognize civil judge awards and arbitral awards given by the mainland. And in 1998, the mainland also signified its agreement to recognize arbitral awards by Taiwan. But as between Hong Kong and Taiwan, the development is somewhat slower because of the difference in the legal systems. I have been in relation with arbitrators in the Greater China region and different districts, especially in the area of civil and business legal areas. They would like to have greater development in this area so that civilian and business activities can be afforded better protection and court awards and can be enforced. So this is by way of my supplement on the development. If members have no particular questions to raise anymore, let's look at the paper CB 4634/1213. I think we can start with the amendments. First of all, Section 5/0003. So let's move on. Next, Section 22. New sections to be added, 22A, 22B. Anything that the administration would like to draw our attention? Well, this is about the emergency relief and the arrangements. The two sections can achieve important aims. First, we have defined emergency arbitrator vis-a-vis the we have pegged our definite interpretation to the arbitration rules of important arbitration organizations, including permanent arbitral, those of arbitral institutions. As for 22B, in subsection 1, we stress that any emergency relief, if granted, will be enforceable in the same manner as an order or direction of the court of first instance with the leave of the court. And subsection 2 is a supplementary provision. If an emergency relief is granted outside Hong Kong, then under what circumstances would a court in Hong Kong be able to enforce the relief? So here we set out the clear principles that the court should consider, such as the nature and the purpose of the relief. As for B, we talk about maintaining this, refraining from taking action that's likely to prejudice the process, and also to preserve the status quo pending the resolution, and also for the preservation of evidence that may be important for the final resolution of the dispute. So these principles will be considered by the court in deciding how to enforce overseas arbitral awards. That is what we propose for Part 3A, two provisions. Are we going to have Order 14 summary procedure applied here for emergency relief? Madam Chair? We are going to resort to rules of the court, which will come in another part. Okay, so wait until we come to that part. Next, 61(4). There's some amendment. This is a textual amendment. But this is only about the wording, so as to align the text with the other amendments. There's no substantive change. All right, 75. Subsection 1. A and B are deleted. Mr. Wong? Well, there are three parts. We have talked about the first one, emergency relief, and here is about the taxation of costs. The present ordinance does not spell out the principle clearly. And here we make it specific. We spell out that it's on the party and party basis, so that the parties can follow a clear set of rules. And this is because Hong Kong International Arbitration Center and the sector have made such a proposal. All right, further points. The next 84, bracket 3 of the Chinese version. But this is about the text. This is a textual amendment to the Chinese version to improve drafting. Yes. In enforcing Macau awards, we noticed that it may be a good opportunity to do some textual amendment to align the wording used. Next, 85. A few amendments here, especially under bracket C. The first amendment is just to add Macau award. 85C to be replaced by another version. No substantive change here, no change in substance. It's just an improvement to the drafting, correct? And that would also align the wording with Part 10 in regard to Macau award. 86 and subsection 3 is of the same nature. 86 bracket 1, we want to align the formulation, the wording with that of for Macau. 86 3, it's the same. 86 bracket 4, the same. So there's no change in terms of the contents.
Now we move on to section 87, 1B and 2. There are amendments to these provisions. Yes, 87, 1B. Again, there is no substantive amendment. It's just to more clearly set out here that now 87 is about enforcement of convention awards. That is the New York Convention. And enforcement of awards are made by party states of New York Convention. 87 has set out two ways of enforcement. First, common law action through the court of first instance, and the other is by summary arrangement. So we are just improving the drafting to bring this out more clearly. Now, I have noticed the Chinese term 依據 in 87(2). Yes, 依據 in Chinese is a rendition of relied on. Is it an a recommendation of the bilingual drafting committee? Because it's a bit strange. Is the Chinese term clear enough here? I'd like to know whether this is a common usage. I'd like to know whether this presentation is a common usage. The same rendition, Chinese rendition, has been used in other parts in the same ordinance. Well, even for, I'd like to know whether the mainland and Taiwan use the same term, 依據, because 依據 is a combination of 依賴 and 根據. Because the Chinese text has always been there, and we won't amend the terminology if not for special reasons. I know I was on the bilingual legislation committee for 6 years. I understand that we had to make up new terms in Chinese. We have to ensure that people can understand our Chinese text. So can we improve the Chinese rendition here of relied on? Yes, we will consider that. 88C. It's just some textual amendment, no substantive amendment. 89. Refusal of enforcement of convention awards. Subsection 1. Again, just a textual amendment to align with other areas of the ordinance. What about subsection 2? Or rather 4? Again, there is no actual amendment. If the award contains decisions on matters not submitted to arbitration. Well, this is a differentiation between decisions on matters not submitted to the arbitration and matters submitted to the arbitrator for decision. Well, in Hong Kong, we've accumulated a lot of experience in law drafting in Chinese. Perhaps we should take the opportunity to review our Chinese text. Some of the principles adopted for translation was not really very reader-friendly. If there were any oversight in the past, perhaps you should take the opportunity to review some of them. Okay, 92 is the same nature of previous amendments. No substantive amendment. All right, 93(2). It's just a textual amendment, no substantive change in content. All right, 94C, the same. So it's just to improve the drafting, to improve the presentation. Yes, all the way to 97. 95, 1 and 4, the amendments are on the same grounds, so we can move faster to the subsidiary legislation, Part 3, and that is the amendment to arbitration or arbitration parties to the New York Convention order. We're using the same structure and model of divisions 2 and 3 of Part 10. Under what circumstances can the arbitral awards of Macau can be enforced? And if there are Macau awards that cannot be fully enforced outside Hong Kong, then the outstanding part of the awards can be dealt with in Hong Kong. 98C is about evidence. Evidence to be produced for enforcement of Macau awards. The duly authenticated original award or a duly certified copy of it can be used as evidence, and also the original arbitration agreement or a duly certified copy of it, and if necessary, a translation of it must be produced. And we've been using the same provisions in the New York Convention. That is, under what circumstances can the court exercise the authority to refuse to enforce some awards. So this is just in line with what's in the New York Convention. And also similar to parts 2 and 3, where the New York Convention is involved, the provisions are consistent. So we'll talk about the procedures. And 98D3. Now, if it is against public policy to enforce the award, or if the award is in respect of a matter which is not capable of settlement by arbitration under the law of Hong Kong, well, these are the same provisions in the New York Convention. So we've just followed what's in the New York Convention. When it comes to reciprocal recognition, I know we practice common law, whereas Macau, they practice civil law. Now, in Hong Kong, we say public policy, whereas in Taiwan, they say good culture or custom of Taiwan. I'd like to know whether there is an equivalent in Macau. Well, if we look at the agreement itself, Article 7, well, they use public order. We use the term public policy. But I think our understanding is just the same, because we follow the spirit of the New York Convention, and the interpretation is narrow. It's just that the terminology used is different. So we, of course, cannot lightly invoke this to refuse to enforce the award. All right? The UK, or I mean the Macau, has got this provision. Can we go on to subsidiary legislation A, arbitration parties to the New York Convention order? Yes. There are 4 countries. They have just added or they've joined the New York Convention. I would like to add that to part 3 of the schedule. We understand that Myanmar in April also became a party state to New York Convention. Please speak into the microphone. All right. Other than these 4 new party states, we intend to move CSA to include a new country, and that is Myanmar, which signed the New York Convention in April for enforcement or commencement in July, probably. So we'd like to rectify that. If the country is included in this schedule, then there is no need for new evidence to prove that there is mutual recognition with this new country. Mr. Ibrahim Sheikh, we are on Sublect A. All right, 10. Part 4. When it comes to the rules of the High Court, we are going to move consequential amendments to rules of the High Court on arrangement for mutual enforcement of arbitral awards, and then emergency relief can also be enforced by amending the rules of the High Court. Well, for instance, order number 73 and number 10 for 22 para 1. There is some amendment in the Chinese text to add direction or emergency relief. And subsection 2 to add BA. This is to echo 22B1. And 3. Uh, 98A1B or 98A1B covers Macau, so we will include Macau awards. And 4, paragraph 4, we believe that it will be more complete if we add direction, the word direction, because if we have the word direction or the word 指示 in Chinese, it will be better. Well, in 10, rule number 10, this is a substantive amendment. You've added emergency relief. I think that is a substantive amendment. And in fact, we already have the word direction in the original text. Well, in English, there are only the terms judgment and order. We would like to add the word direction to add this concept. Any question, please? No? 5. That is to add the word emergency relief to para 5. And 6, 7, 8, and 9. 6, 7, 8, 9 are consequential amendments, and 9. Well, because of 98A, we have to make a consequential amendment here. This is to allow clear procedures for the court to enforce the Macau awards, and also to allow for emergency relief. All right, members, do we have any views? No? And 10, direction, we have expanded that to include all emergency relief. 11 and 12 is just the same. So that's all.
I would like to thank the Secretariat staff for reminding us that today, well, actually, most of the amendments are technical in nature. So I think we have completed the scrutiny. I mentioned one word. That is the word, the term 依據 in Chinese, and I asked if a better term can be found, can be used. And the Secretariat has also mentioned some other points, and the administration has promised to consider those issues. So if there's no need to have further meetings, we can circulate the response from the administration. So if members agree, sorry, Madam Chair, if I may supplement, I would like to thank the Secretariat for raising some questions. And we are actively consider some of the relevant proposed amendments. We are going to present the proposed amendments to the Secretariat for information. First of all, I would like to say something about commencement. We have recently reviewed the ordinance, and we have liaised with the Hong Kong IAC, Hong Kong International Arbitration Centre. They have amended their arbitral rules, and they would like to see commencement sometime a few months later. So for some of the provisions, those related to the emergency relief will commence upon the gazetto instead of relying on a subsequent commencement notice. We are thinking about this approach. If we go down this route, well, I think and I'm sure the early commencement is to facilitate enforcement by way of emergency relief, and also the party and party basis for costs. These things do not need to wait until we have worked out the arrangements with Macau, because for some other provisions we need to wait until they are ready, and then we would commence at the same time as Macau. So that would be the proposed approach that we adopt. And your Secretariat staff also raised some questions about one particular issue. If there are existing applications under Part 10, can there be a fresh application after the commencement of this commencement of Macau arrangement? We said in principle that can be done, but there are restrictions in certain provisions. We will look at the reasons why they want to do this, and whether this is really an abuse of the judicial process. So a lot would turn on the facts. If it's a case of abuse, the court may reject it. We have to look at the reasons. Why suddenly, instead of relying on Part 10, and when it's partially completed, they want to rely on the new Part 4? The court will have to ascertain the reasons. On this point, I have a question. So you encourage those who are being handled would follow through under existing rules, but the parties can choose to do it afresh under the new rules. Well, in principle, if they have rely on Division 1, although it's a bit different from 4, some of the grounds for refusal cannot be found in Part 1. Otherwise, we can't see why some people would like to rely on Part 4 instead of Part 1. Maybe in some cases they need to revoke the existing application and start again. So, in principle, this option is open to them. Yes, but the court, there may be difficulties in the court if it's considered by the court to be an abuse of the process. My understanding is that when you have new arrangements, new provisions, what the benefits is granted to the parties. If a lighter sentence is applicable, the lighter sentence will apply. If a more favorable terms apply, then again the parties can avail themselves to the benefits. So within a certain period, well, new applicants can of course gain access to the new benefits, more favorable terms. But in short, you are giving the discretion to the court. Correct. All right, that's clear. Any other comments? If not, meeting's adjourned. I would like to thank the two members for their perseverance. Thank you.